Most contractors carry general liability coverage with what sounds like solid limits, $1 million, $2 million. They feel covered. Here's what most of them don't know about that limit. Legal fees can eat it alive before the claim is even resolved. And by the time they find out there's not much left to pay the judgment. Stick with me here. What I'm going to show you in this next few minutes is something most agents never explain, and it costs contractors real money when they don't know it. Your general liability policy has what's called a limit of liability. That's the maximum amount that the carrier will pay out under the policy. Simple enough, right? But here's where it gets complicated. Just like insurance, there are two structures for how defense costs, meaning attorney fees, court costs, legal expenses, get handled under that policy. The first is defense outside the limits. That means legal costs are paid separately on top of the policy limit. Your full limit stays available to pay a judgment or settlement. The second is defense inside the limits. That means every dollar spent on legal defense comes out of your policy limit. Your available coverage shrinks with every invoice the attorney sends. Most contractors assume their policy works the first way. Many policies work the second way. Here's why it matters in practice. Say you have a $2 million general liability limit. A claim comes in, your carrier defends the case, the litigation goes on for 2 years, legal fees run $400,000. It's realistic. If your policy has defense outside the limits, you still have $2 million available for the judgment or settlement. If your policy has defense inside the limits, you now have $1,600,000 available. The attorneys already took $400,000 off the top of your limits. On a serious claim with extended litigation, that gap gets even larger fast, and you don't find out where you stand until the bills are already piling up. There's also something called the duty to defend. Some contracts and some policies include language that creates a duty to defend. What that means is that you're obligated to start paying legal costs as soon as a claim is filed, not after a judgment, not after finding a fault, immediately. That can mean significant out-of-pocket exposure before anyone has determined whether you're actually liable for anything. And when the duty to defend is combined with defense inside the limits, those legal costs start draining your coverage from day one. So here's what to do right now. Pull out your current general liability policy, the declarations page, and if you don't have it, call your agent and ask for it. Look for language about defense costs. You're looking for one of two things. Either language that says defense costs are in addition to the limits, or language that says defense costs are included within the limits. If it says included within, that's defense inside the limits. That's the structure you need to understand before you have a claim, not during a claim. If you're not sure what you're reading, it's worth having that conversation with your agent. And here's the broader point. Your policy limit is not just a number on a page. It's a pool of money. And depending on how your policy is structured, you may be sharing that pool with attorneys from the moment a claim is filed. The contractors who don't get surprised at claim time are the ones who understand exactly what their limit covers and what it doesn't before anything goes wrong. And if you want to take a look at your current policy structure and make sure that you understand how defense costs work on your account, reach out. That's what we're here for, 318-423-7445, or go to callwatley.com. Next week, we're getting into indemnification versus duty to defend, two contract obligations that look similar, but your insurance handles very differently. Most contractors sign both without knowing the difference. That one drops next Tuesday. See you then.